It's good that it's recording. This is I'm very excited about today. This is the first episode of Regulation Central, one of our monthly shows here at Chrisman Commentary. We will have a rotating panelist list, but today I'm very pleased to be joined by Peter Idziak, Matthew VanFossen, and Brian Levy. This is your one-stop shop for what's going on out of Washington, what's going on in the world of regulation and compliance. I will not always host. I don't like hearing the sound of my own voice. I'm actually very excited because with a bunch of legal experts today, I don't have to talk at all. So all I will say to start the show is a big thank you to Polunsky Beitel Green, who's a presenting sponsor of Regulation Central. Polunsky Beitel Green LLP is the preeminent law firm for residential mortgage lenders. For nearly 50 years, PBG has provided legal support to residential mortgage lenders, and they understand better than anyone your need for a legal partner to prepare or review mortgage closing documents that are compliant, properly risk adjusted, and delivered quickly. To learn more about the firm, give them a follow on LinkedIn or visit mortgagelaw.com. Like I said, I don't want to talk a ton today. Let's go around the horn and have you all introduce yourselves. Let's go alphabetical order by first name. Brian, you first, Matt second, Peter third. Brian, can you give the audience a little introduction here, please?
Hi, everyone. Thanks, Robbie. Brian Levy here, and I'm not in my normal blue collared shirt like the rest of our panelists here because I'm actually on summer vacation here up at Northern Wisconsin summer camp. But apparently regulations and legal interpretations don't seem to stop for my vacations. So here I am, but the next time I'll be better shaven and better dressed. I'm also a mortgage attorney who has a blog called Mortgage Musings that some people like to read. And I really like to write more than anything.
Fantastic. You're also a featured thought leadership author on the Chrisman website, as is Mr. VanFossen. And Peter, we hope you do that too. But Matt, can you give people a background on yourself?
Yeah, Matthew VanFossen. I'm the Chief Executive Officer of Absolute Home Mortgage, a mid-sized independent mortgage bank out of New Jersey. Also the CEO of a company called Mortgage Automation Technologies. We're a fintech leader in the space, in particular in the point of sale space. And I am a self-proclaimed regulatory geek. I love talking regulation, like being involved in groups like CHLA and the Mortgage Bankers Association, always trying to go down to Washington, learn more and engage. And I am a 20-year mortgage professional.
Very cool. Very cool. I enjoy spending time with you. I'm supposed to be on the East Coast next month, so hopefully we can link up one way or another.
I expect you in a suit the whole time too.
Well, at least the top part. Who knows about the bottom? But yeah, we'll see how it goes. And when I swing down to Texas, my main man for stuff down there is Mr. Idziak. Peter, can you give the audience a little background here?
Sure. My name is Peter Idziak. I'm the Senior Associate Attorney at Polunsky Beitel Green. We're a document preparation and consumer finance firm that specializes in the residential mortgage space. Been in the industry for about 10 years. And before that, I worked at a large New York law firm in their corporate bankruptcy group.
So we have two Harvard law guys here today. Mr. VanFossen, you were denied application. You couldn't make the cut. What's
well, I have to correct you. I'm Harvard undergraduate at UT Law.
Oh,
so I didn't make the cut either. They didn't want me back.
All right. Well, one Harvard law guy.
You should have told Robbie that before. He would have been way more impressed with UT Law, as rightfully so.
Yeah. Oh yeah, that's right. Peter is a UT Law alumnus. I like that. Well,
I got stuck in the mortgage industry too early. I probably should have took the LSATs and went through. I was talking to my good friend Wayne Watkinson about that yesterday. I was like, I think I might want to go back to law school eventually. He was like, don't bother. It's too much reading.
Agree, Brian? Too much reading in law school?
If I was literate, maybe.
All right. Well,
I think I've got unstable internet over here.
Yeah, no worries. Well, we'll go to Peter first on this. I was going to say, speaking of illiterate, let's talk CFPB. Mm-hmm. They no, kidding here. They launched an inquiry into junk fees in mortgage closing costs back in May, and I'm sure one of you will invoke this statistic of 97% of people are against junk fees. It's like the 9 in 10 dentists recommend Colgate. I'm like, who doesn't recommend Colgate brushing your teeth or whatever? You know, who likes junk fees? But anyways, Peter, what's the latest on the inquiry and what's been going on in the junk fee space?
So they had issued a request for information, and the period for commenting on that had just closed. So, there have been several industry groups that have given comments. I'm sure lots of consumers and consumer advocacy groups as well. I think your point is right, though, Robbie, that the CFPB is sort of winning the war of perception, because we're all talking about junk fees, sort of assuming that there are junk fees in the mortgage space. And some of the sort of examples or proposed examples the CFPB had were credit reporting fees and title insurance premiums. And there's good arguments that the fees themselves are necessary; they're not junk. So you're seeing a lot of industry pushback right now and a lot of comments. Where the CFPB goes next, it's a little unclear. And I think it's important to know that this is situated in a larger Biden administration initiative against what they're calling junk fees. So not just in the mortgage space and not just in the consumer finance space, but sort of across all consumer products. So this is one instance where the CFPB is sort of following a Biden administration priority as opposed to getting out on their own.
Yeah, I would cite some of the commentary that we heard at New York Secondary. Director Chopra had given some public commentary at the event, and I agree that it was a little theatrical in sense, but there is some truth to it, and there's some more detailed, if you get into the weeds, some detailed items that we should take a look into. Notably the title insurance fees, lender paid title insurance. That's something that we definitely have to have our eyes on from an industry standpoint, because they're looking at the lenders to potentially pay it. And all that would do is increase origination fees, right? We can't go bolt on an additional $1,800 to $2,500 per transaction when lenders are still, in large cases, making losses. So they'll make up for it elsewhere and probably, potentially increase origination charges to compensate for it. And then, you do see a lot of pushback from the title insurance industry on these. The title insurers are definitely out there and stating that it's not a junk fee. Consumer protections are there with title insurance that it is a necessary item and could not be construed as a junk fee. But now you see the emergence of new things. If you go look over at the GSEs and some of their pilot programs over the past couple of years, for example, in the emergence of attorney opinion letters and AOLs, and you look at the timing in the market, not only the election cycles and looking like the administration making it look like they want to be proactive on this, but also where we're sitting in the economy and the fact that rates look like they're going to be trending down over the next 18 months based on some of the MBA data. We could be looking at some refinance transactions coming in, and with that, lenders are going to be looking for ways to find out how to reduce overall refinance costs. And attorney opinion letters may be a vehicle with some of the GSEs that they are saying, hey, we'll buy these loans. And lenders may look at that as a way to bring costs down for the refinance customer. So I think that the AOLs are very interesting to keep your eye on. And I also think that our title partners really need to look at what they're charging. I see a lot of things on settlement transactions with the emergence of the remote online notarization and the emergency e-close. Well, I do see still title companies charging settlement fees, doc preparation fees, document storage fees, and printing fees. And I find that interesting that, maybe we want to look at this, and if we're looking at settlements that are e-closes, being a little bit tighter on some of the fees that are being charged out there, so there can't be a warrant or claim that says, well, these fees are not actually being performed, these services are not being performed. So definitely a lot to look at with the junk fees area.
Yeah, and if I can just add, Matt, those are some great examples, and I think all three of you highlighted the issue that I kind of want to stay at a little higher level on, which is that everybody in our industry now with this junk fee discussion has lost the narrative battle, and we have to claw our way back up. And what I mean by that is frankly, junk fees was a word that we invented. Like, we called it that. That was stupid. I mean, that was just, terrible from a narrative perspective to call anything that we do a junk fee. Well, they're throwing it back in our face in a multitude of ways. And I think everybody in the settlement service industry, and this does tie into the NAR discussion, but the title insurance versus AOLs, all these specific issues, credit bureaus, credit reports, it's all, what value are you providing to this transaction to the consumer? And if not, you're a junk fee, you know? And I just think that over the next few months and years, and certainly depending on what happens with the administration in November, we're going to be clawing our way back, and everyone's going to have to demonstrate their value to the consumer.
Yeah, Brian, what it also is interesting is I tend to agree with the director on a couple of the commentary he made, which is interesting. A mortgage lender coming in being like, "Hey, I completely agree with the CFPB," but he did make on the credit fees topic. He made commentary and alluded to a universal reissue key, like a methodology where consumers should be able to share their credit report. So get it pulled once in the shopping phase and really reduce credit. And when you go look at some of the counter issues to that, the triggers bill that NBA has out and the consumer harm that's done by when their first credit report is pulled and then they get 300 phone calls in the next 24 hours, and then how it could potentially, because of the credit fee increases that have happened, many lenders have shifted to paying upfront credit report fees. And if it's a $50 or $75 fee a customer has to pay to apply for a mortgage every single time, it may discourage them from shopping, which was the opposite of what we got with TRID with the loan estimate and know before you owe. So, I actually like some of the commentary that he was making about maybe finding a vehicle for a universal reissue where obviously a consumer can't shop their credit report because we don't know if it's accurate, but if there was a global reissue key that they can give to lenders to pull down from a single source, I wouldn't necessarily be opposed to it. I think that's a good idea.
So, and I'm not even sure if this is what the director was going towards, and we may be getting a little off topic because we're now talking about credit reporting and credit bureaus, but I don't see why, from a technology perspective in 2024, we can't have direct access to our credit and provide direct access to our credit to creditors, potential creditors, or anybody else. The role of the credit bureaus today seems to me to be a function of old technology, with blockchain, with our cell phones. I mean, we can give access to all of our creditors directly to a potential creditor or to anybody that needs to see our credit. Of course, there's other things, the medical debts thing that they want to take that out, so. But I think it's really it's an interesting area. And we've been locked into this, this 3 credit bureau system since the 1960s. And one has to wonder, if you were designing it today, would you do it the same way, and would the costs be the same? I mean, it's sort of a bottleneck that, like, the realtors have the access, they control the MLS. Now you've got the bureaus controlling your credit, and that's, of course, the data security issues and all that as well with that model.
Yeah, I agree with you. Sorry that, from a lender's perspective, what we're really talking about in a lot of these are third-party fees. These are not fees that are, additional profit to the lender. Like, our industry, from the mortgage lender side, has a huge incentive to see these costs reduced. And I think to the extent that Chopra is sort of using his bully pulpit to force, all these vendors to sort of sharpen their pencils and find out where they can reduce their costs, or like with the GSEs, sort of incentivize them to accept attorney opinion letters instead of lenders' title policies. Like, there's definitely a benefit to that. And for those out there that sort of wonder, well, why doesn't the CFPB just sort of go after title insurance fees themselves? Well, insurance is regulated at the state level, so they lack the ability to regulate the pricing on that. But this is sort of, I think, a creative way to sort of, try and use their federal authority in the bully pulpit to have state insurance commissioners taking a second look whenever rate increases are requested, and really bring the issue to the forefront.
Matt, quick follow-up before I ask a question here. So go ahead, Matt.
I actually think that was perfect.
Okay, cool. Well, so let's be progressive here. What is the timeline going forward for this inquiry, or what happens at the end of the inquiry? How does it progress in the future? Peter, maybe you're a good place to start.
It's the CFPB sort of works on their own timetable now. The request for information, the comment period is closed. they're not under any obligation to really do anything at this point. I'm sure they will. The question sort of internally is, are they going to try to rush to get something out, under the assumption that you're going to have a Republican administration come January? Because with the director now being removable at will, Chopra has to know that he's out immediately if Trump wins. So I think you will see them try and put something out, whether it's an initial rule proposal or something else prior to the election. I'd be surprised if they didn't.
Yeah, and
Yeah,
go ahead.
Well, I was
I
just
was
saying I
gonna
agree
say-
with Peter because I think that they're trying to issue a lot of other regulations. They've just come out with the servicing reg, which was kind of half baked because they didn't address the LEP issues. They just kind of said we're gonna address LEP, and that's not really a advanced rulemaking. That's not a proposed rule. That's just an advance notice of proposed rulemaking. I don't know. So they're trying to get a lot of things out before the election, it would seem. And of course, if the election goes in their favor, if you see a Democrat elected president, we may very well find that they're the dog that caught the car. They may not know what to do now that they've actually got the power to do what they want to do and don't have to worry about a change in administration.
Well, I also think it's important to note that there is going to be a change in administration no matter what. There's no guarantee that the Harris administration will carry over. You could see different policy. You don't know. The only thing that is certain now is that there will be an administrative change. Usually this time of year, we're looking at CFPB, putting out their agenda for the next year carryover. And, like Peter said, we don't know where Chopra's head is going to be at, with writing that agenda. You might be able to see, to answer Robbie's question, some fast tracking action here to try to get some things snuck in before any potential administration change.
What do you think Chopra's lasting legacy will be? If Rich Cordray drew the ire of IMBs and it was a little more laissez-faire under the Trump administration, what is Chopra going to be remembered for? Matt, what's your opinion?
Chopra's a very interesting. I've had the opportunity to meet with him several times, and the thing that I find notable was that it seemed like mortgage lenders were not his target. If I go back and I look at Cordray versus Chopra and two Democratic appointees, it seemed like Cordray had a target on mortgage lenders' backs. And he kind of came out and straight said that. And I think that the industry has matured exponentially over the past decade. And, I think that I've even heard commentary from him to the extent that we've done a commendable job as a mortgage industry and lenders in adopting and implementing regulations, implementing the controls. Default rates are down, loan performance is up. And we weren't necessarily viewed as this problem child by the director. And I do think that I don't want to say they were lax. Lax isn't a good word, but it seemed like that he put his focus potentially on some more other industries, more of the payday lenders and some of the short-term debt and these pay now or buy now, pay later programs seem to be more of his focus rather than what we saw under Cordray.
Peter, we've had several discussions about the CFPB. What's your lasting legacy of this administration?
Well, I think one of the interesting things about Chopra is that he's very concerned with sort of the potential negatives or risk to consumers of new uses of technology. So he's a younger director, he's in his 40s. And so you might just have this opinion, well, he's going to be very, pro-technology, like let's take the human element out and eliminate any bias. But, the CFPB has really come out with a lot of, statements, regulations, like dark patterns, and other sort of, ways that like automated decision making can reinforce stereotypes or discrimination. And I think, because as AI is sort of becoming sort of a larger conversation generally, like that may be, in addition to what Matt said, which I agree with, like another part of his legacy, that it wasn't sort of this adoption of technology to sort of, take out the human element that might lead to discrimination.
Very well put. Matt, any last word before I move on to a fun interlude
Just
subject?
to piggyback on that, we saw that resonate even through the GSEs when we started talking about the algorithms inside of an appraisal bias and some of the AI that started being used. So, it was interesting that, Chopra brought kind of that new wave into the regulatory of introducing that technology. I saw it too. So I agree with what Peter said.
So as I tease there, we do have a fun interlude before we get into the NAR settlement and maybe some dual licensing stuff. Peter, before we came on, you had mentioned that there was the CFPB funding structure question, but the Fed has actually been operating at a loss. And you're the expert here, not me. So what intrigues you about this? And let's kind of start the discussion that way.
So, at the end of last term, the Supreme Court came out and upheld the CFPB funding structure. Oversimplification, but the CFPB is essentially funded out of the combined earnings of the Fed. Well, since September 2022, the Fed has been operating at a loss. So an argument's sort of been developed by a lot of litigants involved with the CFPB that any money appropriated to the CFPB since September 2022 is unconstitutionally appropriated. No profits, nothing can be sent to the CFPB. So any enforcement actions they're taking with those unconstitutionally appropriated funds, are unconstitutional themselves. So if you thought, well, this is a settled issue, it's not. And, just within the last month, you're seeing quite a few litigants that have raised this issue in court cases with the CFPB. And it'll be interesting to see how that comes out. I know Brian probably has some thoughts on that. We were talking about before the podcast.
Yeah, so the issue is the language of the enabling statute says that they're going to be funded out of the Federal Reserve's earnings. And the word is earnings. And earnings is, sort of commonly thought of as profits, but in the context of the Federal Reserve, it may not make any sense. And I'm sort of giving you the counter argument to the arguments that have been sort of set out. And Jerome Powell himself made a comment just recently that, we can operate at a loss. It doesn't, basically he's saying we can print money if we, we're the Fed. There's no such thing as a real loss here. If you look at just normal accounting standards. So I don't think it's a settled issue. And the other thing I would add to that is that the appropriations case, which came out 7-2, kind of rested on similar arguments. You want to go back and textually look at, is this a constitutional appropriation? And when you have a 7-2 decision written by Justice Thomas, I think that, it relies on sort of all this historical data, historical case law of parliamentary issues in Britain. It's kind of you could decide on either way of the coin if you're a judge that way, right? You could really say, well, it is or it isn't constitutionally permitted. And if 7 of the justices were willing to say, nah, we're not going to shut down this agency entirely and say it's unconstitutional, I don't think they're going to go for this. That would have been the grand slam out of the park home run win against the CFPB. I think they're going for just a regular grand slam home run for the last 2 years of the CFPB's operation. I don't think there's an appetite at the Supreme Court to completely eliminate independent agencies on constitutional grounds or on textual grounds. So I think it's a situation where you're gonna you can probably make a lot of hay at the appellate level, but I think ultimately the CFPB survives. And then the question is, did they follow the right processes? What's the role of Chevron deference in whatever they're doing, or the lack of Chevron deference, and those types of issues, as opposed to knock them out of the park the whole way.
Matt, my free time is spent, reading sports articles or figuring out what the fish are biting on in the streams. This is what you spend your free time on geeking out over. So where's your mind go when you hear this discussion?
It's interesting. I think the CFPB is here to stay. I kind of look at this as white noise. Some of my industry peers are like, yeah, down with the CFPB, right? It's going to come all crashing down. I even with the appropriations, everything, it didn't go through. Our regulations are here to stay. Let's face the facts here. We spent billions of dollars and a decade implementing sound controls. Our businesses are better for it. They're safer for it. They're more secure. We're more compliant. We're producing better loans than they ever have. It produces less risk for private capital-based IMB lenders when they need it. I'm not by any means, sitting here saying, yes, more regulation, but what I'm saying is the job has been done. And the CFPB does have a purpose, and the regulator, as a prudential regulator over the mortgage lenders, it has a purpose. I just think that these latest findings with the appropriations and the underfunding, it's just going to go nowhere. It's going to be a talking point, and the CFPB will be here to stay.
Which, Brian, Peter, either you want last word before we move on to the NAR settlement? Peter, anything?
I think ultimately I agree with Matt and Brian that the CFPB is here to stay. I think with this funding argument, it will be interesting because a lot of these cases are being brought, in the Northern or Eastern District of Texas and going to go up to the Fifth Circuit, which has shown, I guess I'd use the word hostility to the CFPB. So you may have this, as Brian says, ultimately the Supreme Court will rule in favor of it. It'll be interesting to see what the Fifth Circuit does, because that they're going to hear it at some point, and how they turn out. Because as Brian said, 7-2 decision, and Thomas sort of, you would think, could think this through, and the fact that this wasn't addressed in the case from this past term would sort of be seen as a big oversight, I think. So yeah, I agree that the CFPB is here to stay. I think all the sort of constitutional challenges to its structure and funding will run their course.
Robbie, before we move on to NAR, I believe Brian said something about Chevron. I actually have a question about that for the co-panelists. From how I understand the Chevron case is that the regulators' opinion of direct regulation is now called into question, where it was almost taken as the rule of law previously. Where do you guys think that kind of like ties in? Like, I could cite an example, like maybe CFPB interpretation of Dodd-Frank, in particular MLO compensation. If you look at the MLO compensation provisions, it's maybe like 2.5, 3 paragraphs, and it's very direct. And then there's all this alternative interpretation that came out afterwards, things like open-ended HECMs, the home equity line, or not home equity, the reverse mortgage, provisions on paying open-ended comp. Think about comp plan buckets. Does that kind of now get called into question with Chevron of all these, these outlier opinions that are not directly written? And does that cause Congress to really have to do a lot more work now?
You've got there's like a lot loaded in there, but let's just stay on LO comp for a second. And the role of Chevron deference. So previously, before the Loper-Bright decision, that's the case that unwound Chevron deference, courts were obligated that if a regulation wasn't totally crazy, that they had to follow it, whatever the regulatory agency decided. And in fact, the regulatory agency could change its mind. Mm-hmm. With LO comp, the things you're citing, those aren't even, like, the regulation was issued in 2011, effective 2012. There has not been any amendments to LO comp. There haven't even been any consent orders since about 2015, and consent orders are not, entitled to any deference whatsoever. But the CFPB will cite it as their interpretation, and then the kinds of things that you're talking about were in the supervisory highlights that they raised as issues. But you have to apply facts to the law there. But that regulation hasn't changed at all. There hasn't been any additional official commentary. So that comes into play, I think. And some people will say, well, there's gonna be more regulatory challenge. And my feeling on it is that it'll come up more in an enforcement action. If the regulator tries to enforce the regulation in a particular way, and somebody can say, well, your interpretation as against what I was doing isn't entitled to deference. We can argue about that, as opposed to previously when the regulator say, look, the court's got to follow interpretation, so you're going to lose with your interpretation. Now you can say, well, we'll see what the judge has to say. Can you guys hear a loon?
No, we can't.
No.
Zoom, I should say Zoom,
I can hear a
Zoom is
loon back.
actually very good for getting rid of background noise. Peter, weigh in on this quickly before you can address the yellow comp thing. You can address any other.
I'll just speak up like a little bit more generally that following what Brian said, Chevron had a two-step process. First, you had to determine whether a statute was ambiguous. And one of the things that the Supreme Court said was, one judge will say, well, no, it's not ambiguous, and another judge will, and there's no real standard here. So it's sort of this unworkable, standard in the first place. What still remains is that a court can take into consideration the fact finding and the reasoning of the agency tasked with issuing the regulation. But they don't have to defer to it. So in a lot of these maybe highly technical issues, whenever you get in front of a district court judge, they're not going to have the ability or really want to do the work on very technical, environmental, scientific things. So at that level, I'm not sure you're going to see a lot that changes. What you might see on the agency side is that they're going to spend more time and effort coming up with sort of a body of evidence and reasoning for why they've interpreted something the way they have. And there are quite a few statutes too that baked into them, do say that the director or the head of an agency or the agency itself has discretion to make adjustments to that statute as they see fit. So there's not really going to be like a one size fits all answer here. I think, sort of putting on my hat, whenever you see something, a regulation that's sort of like hotly contested, maybe in the, the healthcare space or involving religious freedoms or anything like that, you will see judges sort of, much more frequently disagreeing with an agency's interpretation. But for things that are highly technical, you may see courts continue to sort of follow on just because they're not really equipped to do the work of it. But I think that there will definitely be changes. And what's also been suggested is that you will see agencies that say, well, court, if you're not going to defer to our, expensive and time-consuming, rulemaking process, well, we're just not going to make a rule. We're going to say, we're going to bring an enforcement action, either get a consent order or go into a court that we think is favorable and just say you violated the underlying statute. And, I don't think that's really good for anybody because industry likes, knowing what the rules are ahead of time. And you like the Administrative Procedures Act process because you get to, have your say. So I think there will definitely be impacts, but it's probably a little bit more mixed than people think. And one of the interesting things about Chevron is that the original Chevron in 1983 was a case against the EPA that basically said the EPA interpreted a pollution control statute in a way that was too business friendly, and that they should have interpreted it a way that was, sort of more like consumer or quote environmentally friendly. So you may also see like consumer groups come in and challenge CFPB rulemaking, saying, your interpretation, maybe you made an exception for business or like ability to repay. The safe harbor is a regulatory creation. It's not in the underlying statute. And say, creditors aren't entitled to that. And so it won't always be, sort of a pro-business change post-Chevron.
Matt, you satiated with that? And any follow-up?
No, I'm still learning about Chevron, right? I'm trying to figure out and navigate, what it means to an IMB on a daily basis. What does it mean to our regulatory policy? And, it's interesting because it almost came out of nowhere, right? And, I've been, working with MBA, or watching the policy that they've been, trying to interpret and put out of how it really trickles down to the daily lives of, owner operators of IMBs, and does it create more risk, less risk? And I agree with Peter. One that we don't want is the rules being made while you're already in jail, right? You don't want to go to an arena where, we have no guidance on, how we're supposed to be operating, and then, rely on rule by enforcement. We've seen what that looks like, 10 years ago, and that was difficult, right? It was a lot of studying, pending cases, and, when settlement comes out and adjusting policy on the fly.
I would add that Chevron, or the demise of Chevron, is going to make the job of compliance professionals much more difficult. Because in the past, And frankly, it's a relatively new part of mortgage lending. It really, really sort of took off after Dodd-Frank. So we're talking about less than 20 years old of having compliance professionals embedded in mortgage companies. And, they've always taken it as sort of doctrine that whatever the regulation says is what you have to do. And their job is to tell you how to follow the regulation. Well, with, with the ability to sort of question what it is that the regulators are telling you to do, that's a skill set that most compliance officers don't really have, and maybe they shouldn't. It's a skill set that lawyers should have, to question whether something makes sense and whether there's a challenge to it. But it does make the job more difficult, I think.
Brian, that's why I brought up MLO comp. Everybody's been questioning MLO comp for the past decade.
Well, it's true. I mean, and so I wrote one of my musings about that very topic. I don't know if you saw that one. There's a picture of Bozo, and I called it Bozo buckets, and you probably know why, because of the buckets. But
Yeah.
I think it's a that's why it's more difficult for the compliance officer, because they're going to say, well, so-and-so is doing this. How are they doing that? That's the question that you always get as a compliance officer. And I don't know how they're doing it. Maybe they're playing fast and loose with their compliance obligations, or maybe they think they've solved the problem. I mean, but I've seen many of these people that think, I cracked the code. I now know how to get around RESPA, or pay loan officers based on products. A lot of that's just wrong. It's just,
Well, it goes back to also it hasn't been tested, right? We haven't seen
more that they haven't been caught.
Yeah.
And I think LO comp is an area that the whole industry needs to be very careful with, because there's class action liability. It's not just the regulators that can bring a LO comp case. And if you think you've gotten away with something, that's a life of loan issue. So it's a defense to foreclosure. So look out if you think that you can just ignore or fudge LO comp because now there's Chevron out there, or Chevron's gone. I wouldn't give that advice at all.
So we're into the last 8 minutes of discussion here, and I do want to address the NAR settlement briefly. I'll try and keep it very pointed. We had months and months of speculation of what was going to happen when this middle of August date kicked in. We're now there. We're here. Peter, I want to start with you. What have we seen in the early innings since this has changed?
It sort of depends on the market. Like here in Texas, and I'm based out of Dallas, we haven't really seen a lot of changes in terms of the number of sellers that are willing to pay the buyer's agents. What you're seeing in terms of like the process changes are, and one aspect of the settlement was that you need a written representation agreement from a buyer's agent before that buyer can sell you a home. So we've seen these short-term touring agreements created that basically have like a week-long period. And in those, there's a new disclosure that basically says, very clearly that compensation is negotiable. So what we have seen is we're seeing much more of negotiation of compensation that's occurring, during the offer, as part of the offer. But so far, at least, and it's very early days, we at least, with the realtors I'm talking to, haven't really seen a decrease in overall compensation, maybe a little bit. And at least in this market, you really haven't seen a lot of sellers that ultimately refuse to pay for at least some of the buyer's agent's compensation. So really, it's sort of just an awareness that compensation is negotiable and sort of additional disclosures.
Matt, you have a look on your face like nothing about this subject pleases you. Where's your head here?
Well, so, it's August 20th. We're 3 days after August 17th. Here in New Jersey, we're one of the states that passed a law, Consumer Real Estate Protection Act passed in July. August 1st was its implementation, and a lot of its implementation mandates were carryovers from what looked like the NAR settlement. I'm seeing interesting things on the street the past couple of weeks. I got to be honest. We've seen real estate brokers take interesting interpretations I was under the initial concept that not much would change, that sellers would still offer the comp, and buyer agents would be getting buyer agency agreements because sellers were offering the comp, and it would be mainly a disclosure issue. And now what I'm seeing is I'm seeing some different stuff. I'm seeing brokerages in their listings very adverse and skeptic about, even if the seller wants to offer compensation, not even telling buyer agents about it, saying almost to the effect of, submit your offer and submit what it is and what you want to get paid, and I'll present it to my seller. And that the listing agent is actually preventing, even if the seller wants to offer the buyer agent comp, from putting it out there. We're definitely seeing an influx of phone calls to listing agents, right? They're already starting to complain this past week of, oh, my phone just constantly is blowing up from buyer agents looking to have the 3-minute conversation. I feel like all I'm doing is answering text messages all day. And I do think that consumers will take time to adapt, probably more so on the seller side than the buyer side. I think the sellers, what's interesting is I'm seeing I thought that it was going to be cheaper to sell your house. I'm seeing the emergence of the 4% listing now. So where it was typically a full boat listing was 6%, 3 to the buyer, 3 to the seller. And then a good discount listing was 5, 3 to the listing agent, 2 to the buyer agent, maybe, or 2.5, 2.5. I'm now seeing listing agents going 4% all in for the listing side only, and pitching it. Well, it used to be 6, now it's 4. And the buyer has to pick to pay their own. So we're starting to see that. I'm thinking that on the negotiation side, that consumers will adjust a lot quicker to buyer agency compensation negotiation, meaning that when they see these buyer agency agreements, the agents may face several challenges. One, in selling the high fees, particularly in the high-end market of the $1 million listings, where you're seeing a $20,000, $30,000 buyer agency agreement. And most notably this week, I've been talking to different constituents, and I was initially under the impression that I should be advising my loan officers to get copies of the buyer agency agreement so we can factor it into our pre-approvals. I've now reversed course on that opinion. And now I've said, you know what, unless it's a seller concession and unless it's inside the contract, I don't want to know about the agreement. We have no dog in this fight. We should not be putting our loan officers in a position where we have to back up the agents or second sell or second voice it. We need to defer our clients to their settlement attorneys. When the clients are asking, what is this agreement? Should I pay it? Should I not? We should not be giving any opinions or advice on that matter. In fact, if the buyer cannot come up with the money to pay the buyer agency agreement and it's not in the contract, we can't hold back the closing. So we should be separating buyer agency from the settlement, because we don't want to actually put ourselves as lenders in a position where we're at the closing table, the buyer doesn't have the money to cover an extra $15,000, $20,000 in closing costs. That's a legal contract between the buyer and the agent. And if it's not inside the sales contract, it's not part of the seller negotiations, there's nothing we can do to stop it. And that puts loan officers in difficult predicaments, because that's the source of their business. So a lot of things are changing on the fly very quickly, and the natural market is reacting. It's going to be something to watch in the next 60 days, that's for sure.
Robbie, I was going to say a lot of things that Matt just said. And in fact, Matt, I might have to quote you in my mortgage musings, which is my
Please.
next one, probably going to cover this topic. But to your point, a lot is changing. We don't know exactly where things are going to shake up. It's all very state specific. And it's all having to do with contracts between third parties that we should not be giving advice, and certainly not legal advice if we're not lawyers, and they're not our clients, on these questions. I mean, lenders historically, mortgage originators have been, very helpful to their realtor and builder business sources in terms of, what do I do with this closing? How do I handle this? How do I handle that? This is their business. I mean, this is straight up, how are they going to adapt to these new requirements and these new obligations? And if you start giving them legal advice about what they should or shouldn't do, first of all, you're probably going to be giving bad legal advice because it's probably wrong. But second of all, you may be practicing law without a license and opening yourself up to liability lawsuits. So I would, be helpful in terms of whatever they come up with. Like if they come to you and say, here's what our contract is. Can we finance these fees? And you might say, well, no, or only if the seller pays it. Whatever, but you can tell them what your underwriting guidelines say, but you can't tell them how to do their deals.
Very sage advice. We are out of time today, gents. I do a lot of these shows, and sometimes I'm thinking, when's time going to be up? This was entertaining, very valuable from start to finish. I look forward to the next show, which for audience that is here, that will be September 17th, 3 p.m. Eastern, 12 p.m. Pacific. Gents, enjoy this very much, and a big thank you to Polunsky Beitel Green. For those of you looking for more info, visit mortgagelaw.com. Mike Fratantoni, I'm on a video call here. Why are you interrupting me?
Ask him what's the rate cut? Quick,
when's the rate cut? When's the rate cut?
Mid-September, man, mid-September.
Mid-September. You heard it here first. All right, we'll see everybody next week. Thanks, guys. Thank you, Polunsky Beitel Green, and goodbye, everybody.
Bye, everyone.
Bye.